Good morning to everybody. Good morning to all the eminent persons, our mentors who have joined us today. And in this bitter cold, we really feel the warmth of all your august company, sir. As it happens every time, it is at the behest of Dr. Paroda, Indian Society of Plant Genetic Resources is aiming to compile comments and suggestions in response to the call by JPC towards the Biological Diversity Amendment Bill 2021. It is indeed possible, with the guidance of you all who were at the helm of NBPGR or who oversaw the formulation of PPVFRA Act as well as the institution, or who headed both PPVFRA as well as NBA. Respected sirs and my colleagues, objective of today's exercise is not to criticize the institution or the law or the process, but to constructively be critical to ensure the improvements. We all know that NBA was established and the Biodiversity Act and rules are in place to ensure conservation and sustainable use of biodiversity and of course benefit sharing. It is clear that the purpose was served to a great extent in establishing a regime of systematic access. In fact, a comparative analysis shows that the Indian system has been broad, comprehensive, and inclusive. However, over a period of time, such laws usually undergo revisions, and the same thing has happened in other countries, for example, in Brazil. And we have understood the common issues in all such revision process have been to ensure that the legal process should not stifle the innovation and development, as well as greater importance or the separate track should be considered for research and development separately from the commercial activities. Facilitating biodiversity R&D cannot be overemphasized considering the seriousness of habitat destruction and climate change. Therefore, objective of today's peer group meeting is to provide logical and well-justified inputs to the JPC to achieve that. Thank you very much. May I now invite the Secretary of ISPGR, Dr. Anuradha Agrawal, to present a formal welcome.
Thank you, Dr. Sunil Achak, for opening the meeting today and providing a base primer for today's meeting. On behalf of the Indian Society of Plant
पार्लियामेंट में एक सवाल पेश है बायोडाइवर्सिटी पर कंजर्वेशन, तो बिल मॉडिफाई करने का है, उसी की मीटिंग चल।
May I request people to put their mics on mute?
You unmute yourself, Madam, now.
Thank you, Dr. Sunil. On behalf of the Indian Society of Plant Genetic Resources, it is my great pleasure and privilege to welcome all the experts who have assembled for today's meeting at a very short notice to discuss some of the amendments of the Biodiversity Act, or rather the Bill 2021. At the outset, it's my great pleasure to welcome respected Dr. R.S. Paroda, President of the Indian Society of Plant Genetic Resources, and as Dr. Sunil has indicated, the motivator for all our activities in society. He is also the founder chairman of TAS. Welcome, sir. Welcome to another stalwart of Indian agriculture, Dr. R.B. Singh, former president of NAS and former chancellor of CAU, besides many other portfolios that he has held. Warm welcome to Dr. P.L. Gautam, former chairman, National Biodiversity Authority and chairperson, Protection of Plant Variety and Farmers' Right Authority. Welcome to Dr. J.S. Sandhu, Vice Chancellor, SK Agriculture University, Jobner, Rajasthan. Our own seniors from their council. A very warm welcome to Dr. T.R. Sharma, Deputy Director General Crop Science, ICR, and Dr. D.K. Yadav, Additional Director General Seeds from ICR. Dr. S.K. Sharma, who was our former director at NBPGR and also former Vice Chancellor of CSK HP Himachal Pradesh Agricultural University at Palampur. Welcome, sir. Director NBPGR, Dr. Ashok Kumar. Thank you for joining us. And I welcome Dr. J.C. Rana, Vice President of ISPGR and country representative of the Alliance for Biodiversity International and CET. Colleagues from the TAS office, Dr. Bhagmal, Dr. J.L. Karihalu. Welcome, sir. I'm not sure whether Dr. Umesh Srivastav has joined us yet. Yes, welcome, Dr. Srivastav.
Dr. Gautam is also there, madam. Dr. Gautam Saab has also joined.
Yes, I have already indicated Dr. P.L. Gautam, welcomed him. I don't know, I hope Dr. Gautam, you could hear that. And a warm welcome to Dr. A.K. Singh, Director, IRI. Thank you, sir, for joining. A very warm welcome to all my colleagues from the Bureau, heads of division, Dr. Gurinderjeet Randhawa, Dr. Veena Gupta, Dr. S.P. Ehlawat, Dr. Celia Chalam, Dr. Kavita Gupta, and Dr. Vandana Tyagi. A very warm welcome to Dr. K.S. Varaprasad, our old colleague from NBPGR and former director of IIOR. Of course, welcome to two guests invited by Dr. Kuldeep Singh, Mr. K.K. Narayanan and Mr. George Thomas, who will be representing the private sector and breeders' perspective to us. And a warm welcome to my core team who have helped in organizing the meeting today, Dr. Pratibha Brahmi, Dr. Vandana Tyagi, Dr. Sunil Archak. Thank you all for coming together at a very short notice. And we hope that the deliberations of today's meeting will help us drafting a clear and important note which will be sent to the JPC, the Joint Parliamentary Committee, that is looking at the amendment bill right now. And we have to send that before 31st January. So we will be doing the points discussed today, noting them and taking them forward in a very short notice. Thank you all for coming. I hope I have not missed anybody. Yes, I think everybody, in fact, who have been invited at this very short notice, very happily agreed to join the meeting, except Dr. Kuldeep Singh and Dr. R.C. Agrawal and Dr. R.K. Tyagi, who had been invited and could not join due to other commitments. Thank you all. And as already indicated by Dr. Paroda, we had invited Dr. Prabhu, but he has sent his points and he could not join the meeting today. Thank you one and all. Back to you, Sunil.
Thank you very much, Dr. Anuradha Agrawal, General Secretary, ISPGR. Before inviting Dr. Paroda to provide his introductory remarks, may I just remind everybody that the proceedings of the meetings are being recorded. Thank you. May I invite now Dr. Paroda, sir, to give your introductory remarks.
Thank you, Sunil and Anuradha, for having organized this meeting at such a short notice. First of all, my personal welcome to all who are participating. I am really overwhelmed by the kind of response that we got, that shows the kind of interest and concern by each one of those who are present today. We called it a peer group meeting because you are all concerned with genetic resources and Biodiversity Act. We were all involved. Dr. Gautam is there. I'm so happy to have him here because he has the experience of both sides, Plant Variety Protection Act and also Biodiversity Act. So he is the most valuable person in this regard, Dr. R.B. Singh and all our other colleagues. But I'm so happy that we are, in fact, generation passing, but the next generation is very actively participating. Most of you, in fact, come from this next generation, and this all revision which is being now called for is likely to be of concern to each one of us. So I don't have to tell about importance of this. The act is important. It was required as sui generis system after the CBD, and we were happy that these two acts we were associated. I myself was actively involved that time, and Dr. Gautam and many other colleagues who were there uh, participating and preparing the draft. Dr. Swaminathan, we had been interacting very actively, and we are happy that these acts were cleared in the record time in the parliament to get the acts of these kinds approved in just less than 5 years period is a remarkable achievement in itself. But when we prepared, obviously everything could not be conceived and experienced, and as we have moved along, we have got more experience. Maybe there are certain concerns, and opportunities are always there for amendment. So we are appreciative of the government to come out with the amendment bill, which is now in the parliament with the joint parliamentary committee. No doubt the notice given to us is very short, and that's why we requested you all to participate and see as to what we have to do. We need not be very exhaustive in our, deliberations. Pratibha Brahmi has been requested to make a presentation on the subject. We are happy that from council, both Dr. T.R. Sharma and Dr. Yadav are participating under mass leadership of Dr. Mahapatra. This subject was earlier discussed, as I understand, and there is already a policy paper on it, which has been passed on to the government, and I'm sure it must have been flagged also to the drafting committee who wanted to bring in amendments. So, but still, if there are concerns, and some colleagues have sent their comments, like Dr. Prabhu, Dr. Tyagi, and I also find that many are keen to further deliberate. So let us have presentation. What is on the agenda, Sunil? Now presentation by Pratibha, I suppose. You are muted.
I'll share that one, sir.
Okay, so if you could flag the agenda, then we can, and then we will request our senior colleagues to come forward after the presentation and highlighting the various proposed amendments and where are the specific issues and concerns which we need to discuss. I understand many issues have been already taken care of. Dr. Prabhu said that some of the concerns relating to the registration and mandate of farmers' right varieties are already agreed to, but maybe there are definite concerns, and my special concern is whether there is delegation for whether agrobiodiversity is being considered as an issue of great importance and relevance to the food and nutrition security of our people, and delegation for this is being assigned to DARE and through Bureau, which is very critical because under treaty, Ministry of Agriculture and Farmers' Right already has that responsibility for multilateral exchanges. So for bilateral also, this same responsibility should be there. So this is the only point I particularly have. I understand there are issues relating to definition, and maybe there are other issues. So I would stop here. Let's try to be as constructive in our discussions today after the presentation of Pratibha, and then see if we can come up with a draft which again is circulated to you, and with your input we can proceed further. Dr. Bansal could not participate. He sent his regret, and Dr. Kuldeep Singh also said he will participate, but maybe I don't know. We also requested Kondania to participate. So he said he will send the comments from industry side. They are already debating it. and they would be sending their representation. So they will share that with us. So we will also have benefit of looking at that as well. National Seed Association of India was also requested. They said that they would need more time, and they are requesting for extending the date for submission. So probably they are going to do it at their own. So that is a good thing. And I'm sure ICR has already been actively involved and must have already flagged. So maybe after Pratibha Brahmi, maybe Dr. Tia Sharma and DK Yadav could give some background as to where we stand relating to issues, and then we can have discussion. So over to you, Dr. Pratibha Brahmi. We appreciate your involvement, and you have been very actively considering all these issues from Bureau side and are aware of what is critical to be considered.
Thank you, sir.
Madam,
Sunil, can I start?
Yeah, please. You will be sharing slides yourself, madam?
Yes, I will. I'm
Please
just
go.
sharing my slides.
Please go ahead, madam.
So is it visible now?
Please go to the first slide and then put it in presentation mode.
Yeah. That okay?
Yes, excellent. Please start, madam.
Thank you, respected Chairman Dr. Padhoda, and all my senior colleagues and mentors. And thank you for giving me this opportunity. As Dr. Padhoda has already mentioned, that there are in the amendment there are some issues which we still need to be flagged. I am just going to present those salient issues for discussion. Sir, to just give a small background, this act was this came into force in 2002, and then the rules were formulated in 2004. And this act is operating through the three-tiered system, that is the National Biodiversity Authority at the national level, State Biodiversity Board at each state, and biodiversity management committees at the level of panchayats or local bodies. And after this act was had come into force and implemented, though stakeholders representing sectors like seed systems, medicine, industry, research, and they had raised some concerns to simplify and streamline the procedure and also the compliance burden. So MOEF had started the revision process in 2018-19, and it went up to 2020. And as departments concerned with the exchange of bioresources, Department of Agriculture and Farmers Welfare and DARE had participated and provided suggestions. So the first draft which was received for comments was in 2020. So this we are going to discuss now, the amendment bill. Although the rules have also been under the review of the authority, and the regulations which came in 2014 for access and benefit sharing after the Nagoya Protocol, these are also with the Ministry of Law. But as I understand, till the act is amended and put in place, these also would need further revision, the rules and the regulations. Also in this background, NAS had conducted a brainstorming session where most of the bureaus and other stakeholders had participated, and there were about 12 recommendations. Dr. Gautam was the chair of that brainstorming session, and there were about 12 recommendations that were sent by NAS to the NBA. And if we see these recommendations, we could see only 2 or 3 of them have been considered positively in this amendment, and still the other issues remain, which we are going to discuss now. So the first and the foremost is that DARE is, had the responsibility and the mandate related to agrobiodiversity, and we have felt there is a decline in exchange of genetic resources after the BDA has come into force. So we would like to flag this as the main issue. And also the second issue is that the breeders which are working in the national agriculture research system, they should be treated at par with the farmers and local communities as far as the use and collection of genetic resources are concerned, as we are creating public good. And also there are some issues regarding the definitions and terminologies like research, agrobiodiversity, commercial utilization, plant breeding occurring in India. These also need to be included and amended in the Act. So just to give a little background, if we from NBPGR side, if we look, there has been a drastic decline in export of germplasm because of these, we feel because of these regulations. So it is almost, we are at half of what we used to be exporting before the Act came into force. And this has also affected the import, because when we are not able to, as a research organization, not able to supply germplasm for our side, many of our requests for import from other countries are also not met. So that is really affecting the agricultural research as such in the country. So our import permit, they are materializing only to the extent, only 1/4 we can say, 27% of our requests are met when we request material from other countries. So some of the issues I am going to list just now. So there is a provision in the Act which says that the authority can delegate power to any member or officer of the NBA or to any other person subject to the conditions such as the powers and functions of the Act, except that regulation for which are put in under section 50 and 64. That is only the, I would say, the offense part of they cannot delegate powers for making offenses under the Act. So all other powers can be delegated. So we would like to, in the amendment bill, they have just added the word delegate to any member or member secretary. So our concern is that after the implementation, there has been decrease in exchange of GRFA. So therefore, we propose that regulatory powers and function or agrobiodiversity, that is mainly the biodiversity for food and agriculture components, that should be delegated to Secretary DARE and DG ICR for expediting exchange of germplasm. And also there is a need to provide for reciprocal exchange under the Act. So accordingly, the definition of agrobiodiversity also has to be elaborated under the Act. Already there is a definition given under section 13(1). That is a very sketchy, I would say. That is just said, agrobiodiversity means biological diversity of agriculture related species and their wild relatives. Whereas we propose that it means components of biological diversity, including their wild forms, which are collected, developed, and maintained for the purpose of food, fiber, fuel, health, and nutrition security. So that means the total of biological diversity for food and agriculture. And there is a section of definition on section 2 of the BDA, where the biological resources had been defined earlier also, and now it has been amended. The earlier definition was the biological resources means plants, animals, and microorganisms or parts thereof, and their byproducts, excluding the value-added products. But the amended definition has slightly modified, and it says biological resources include plants, animals, or microorganisms, or parts of their genetic material and derivatives, excluding the value-added products. So this parts thereof, the exclusion of this has created a confusion, because when we talk of any organism, the part also is, their parts are also part of the biological resources as per our understanding. So this needs to be retained. And they also had earlier agreed to maintain the status quo of this definition. And also the commercial utilization has been defined earlier in the Act. That is use of biological resources for commercial utilization, such as drugs, industrial enzymes, food flavors, fragrances, but does not include conventional breeding or traditional practices. So here we had suggested to include commercial utilization always means when there is a monetary gain from the use of resources. So this has to be qualified by saying that commercial utilization means end use of biological resources for monetary gains, but does not include conventional breeding. And this conventional breeding has also not been defined in the Act. So we say that conventional breeding or traditional practices or methods used by breeders for genetic improvement of. I will further elaborate on this. So in spite of our request, the conventional breeding has not been defined in the Act. This has been also brought to the notice of the authority many times. So we propose that this conventional breeding or traditional practices means methods of breeding practices that are being used by growers or cultivators, farmers or local communities or breeders in India in agriculture, forestry, aquaculture, horticulture, sericulture, poultry, dairy farming, animal husbandry, for beekeeping, etc. Now, coming to the phrase which is used in Section 3 of the Act, that any biological resource occurring in India or associated knowledge is the subject of this Act. So this occurring in India has not been defined. We understand that all the resources which are occurring in India are not native to India. They may be imported, they have been used, or they have been naturalized in India. So there are four types of resources occurring in India, that is indigenous native biological resources or biological resources that are available in India but were imported long time ago and have naturalized. And there are resources which are imported recently, we can say post CBD, or that may arrive in future. So this regulation need to define which of these categories it is trying to regulate. So regulation need to be defined accordingly. So the definition of commercial utilization, I have already discussed, I think. Now coming to Section 4, this is regarding the transfer of knowledge for commercial purposes. So all persons who are covered under Section 3(2) or anybody who is transferring research results, they were provided for in Section 4. And the amended Section 4 reads, all the other things remain same. They have added an exception, except the codified traditional knowledge, which is only for Indians. So there is a need to define what is codified traditional knowledge. It is not clear whether it should be retained or omitted from this definition. So the amended bill reads, no person or entity shall share or transfer any result of the research on any biological resource occurring in India or obtained or accessed from India or associated traditional knowledge. So when already associated traditional knowledge is included, what is the purpose of or the rationale of including codified traditional knowledge? That also needs clarification. So under Section 4, they had earlier exempted public sector establishment through Section 5(1) and 5(3), where collaborative research was inclusive of approved projects by central government under the policy where NARS got covered. So in the current amendment, the proviso should be with the qualification if the research results of research shared other than published in research paper or dissemination of knowledge in any seminar or workshop used for further research by person referred to section 2 of the section 3. Then registration with the NBA would be necessary. So ideally, the value of any such registration is only for the purpose of transfer of benefits of financial nature. So this provision should be deleted. That it would be, it would be not good that for Indian researcher, if research is published and not available for use by other foreign, while the resource is his. So therefore, when a resource is researched by the Indian, this provision does not hold good. So this restriction also does not exist on any patent in anywhere in the world. So this input we have received from Dr. Prabhu, that the folk varieties and farmers varieties have been defined in the bill. And it says that folk variety means cultivated variety of plants that were developed, grown, or exchanged informally among farmers. And farmers variety has been defined, which has been traditionally cultivated or evolved by farmers in their field, or is a wild relative. So the folk variety, which is not farmers variety, so there is no such folk variety which is not a farmers variety. So already farmers variety is defined in the amendment. So as defined, it seems to include any new variety also. So this will encourage or pilferage or an inappropriate use of available variety in the country. And it also does not clarify that farmer is the developer. So it says that any variety developed which is grown and exchanged informally among farmers. So this can be interpreted as any variety developed elsewhere by anyone and can also be grown and exchanged informally by the farmers to become a folk variety. So this is non-avoidable and this is adding no value to this subsection. And also land rates has been defined as a primitive cultivars that was grown by ancient farmers or their successors. So the PPPFR feels that land race is not a primitive cultivar that was grown by ancient farmers. The term primitive necessarily refers to an early stage of evolutionary or historical development. Varieties such as of mango, such as Langda and the Sherry of mango, can never be a land race, as these are not primitive cultivars. So therefore, use of definition internationally should be used that population of cultivated plant species with historical origin and identity adapted to ecological conditions and set for farming practices, which is traditionally followed and grown by local communities for several generations. And if land races are defined in the amendment, then the most land races will not be under cultivation by any community and will be en route to extinction, since no one grows any primitive variety. So an uncultivated or naturally growing or wild primitive will not be a land race. So a land race has to be associated with a cultivation and in continuity and in a relatively large area by choice of the community. Otherwise, this will be relegated to a material which is under in situ conservation. And that means once upon a time. So, or a wild relative or a wild species or genetic stock nursery with the breeder, these can be bioresources conserved by the farmers, but not categorized as land races. So these are contradictory to the definitions. Now, similarly, the biosurvey and bioutilization has been defined under the previous act as these resources that nobody can use these biological resources for commercial utilization or biosurvey or bioutilization. So the amendment bill, this has been deleted and has included, I would read the amended section, that no person other than the person covered under section 2 of section 3 shall access any biological resource or its traditional knowledge for commercial utilization without prior intimation to the state biodiversity boards provided the provisions of this section shall not apply to the codified traditional knowledge. Again, this phrase has come. Cultivated medicinal plants and its products, local people and communities of the area. And they have also included now the registered Ayush practitioners who practice indigenous medicine systems. So we propose that the breeders who are collecting resources from different states, who are working in the national agriculture system, and they are generating public good, they should also be included in this section, section 7. So these were the major statements which we feel need revision or discussion among this peer group. There are certain amendments which we appreciate, and they have brought the ease of operation. This is just for the information. I think most of you must have read about these. And also, as stated by Dr. Broda in the introductory remarks, that some of the things have been eased. That means in section 6.3, the Indians who are seeking IPRs on any invention, they need not take prior intimation or prior information to the NBA. They need to take prior approval only at the time of commercialization. So in the original act, this was for required at the time of applying for any IPR. So this has been eased for the researchers. And then the amendments to section 3, that Indian seeking PVP exemption are exempted from the provision of this section 6.1 for any right granted under the protection of plant varieties. So the new section 59A has been added in the bill, that the provisions of BDA 2002 shall not apply to any person who has been given approval or granted any right relating to protection of plant varieties enacted by the Parliament. And also, when we are sharing material, only now the section 3, which is amended, that only the foreign controlled companies are required to take approval from the NBA for getting resources from for use within India. So as per this act, now we will be able to share more material with the companies, except the foreign controlled companies would need approval from the NBA. And the use of biological resources. So therefore, the issues for deliberation for this peer group, very simply I will put as the biological resources used by research community, especially the components of genetic resources for food and agriculture, some important definitions, and the overall impact of excess regulation on agriculture R&D. Thank you very much, sir. So I would just unshare and then we can move on to the discussion. Dr. Sunil?
Yeah. May I stop your sharing now?
Yes.
Thank you very much, madam. That was an excellent presentation to start with. May I now request Dr. Paroda to preside over the discussion part, sir?
Well, thank you, Sunil, and appreciate Pratibha for flagging the issues very clearly. I am sure most of our colleagues participating today would have got idea, those who had not earlier gone through in detail relating to the issues concerning amendment bill. So I think we need to take most of the important issues which have been flagged. And at the end, you had said in the slide, 3 issues were there. One is about the delegation of responsibility for agrobiodiversity and understanding clearly the definition of agrobiodiversity.
Yes, sir.
And the second one is about the definitions of some of the definitions which need clarity.
Yes.
And one point which also came to my mind was that why so much emphasis here on Ayush practitioners?
Yes, sir.
I think is the lobby, some lobbies forcing or acting Ayush practitioners can have all the free hand, and why not farmers dealing with agrobiodiversity, which is relevant to food and nutrition.
And
So-
as well as researchers, sir. Our concern
As
is
well as-
researchers.
Yeah. So I think these are some points, but to begin with, I think most pertinent would be to hear from Dr. Gautam first. Professor R.B. Singh, we will request slightly later after other inputs have come, because
I
he
see
would-
Dr. Dhillon also have joined.
and Dr. Dhillon
Welcome.
also. We are happy. I mean, all important people are there. So maybe first Dr. Gautam, and then we will come to Dr. T.R. Sharma and Dr. D.K. Yadav, and then come to the former directors of NBPGR and others then can butt in. And Dr. R.B. Singh, I would request later to maybe give his, more comprehensive remarks and assessment. Dr. Gautam, please.
Thank you, Chairman, sir. And I really welcome all the peer group participants to this very important interaction. You have very nicely elaborated the stages, how this act has been enacted. And Pratibha has really done a good homework in putting the real issues which we must deliberate and make a consensus for sending to the Joint Parliamentary Committee. Well, sir, we must acknowledge that the government has taken very historical decision in implementing this very important legislation in 2002. As we moved on, we could find difficulties and some problems in the implementation phase. And right from the implementation beginning, there were areas where the need for making changes in certain provisions were highlighted to the government. It's good of the government that after many deliberations at the NBA level, at the ministry level, the amended bill, which is under consideration with the Joint Parliamentary Committee, is now available for comments. I would not like to say much on what we should rather there is no limit, because every point will be commented upon. But our concern as a scientific organization should mainly focus on the areas which are research related and farmers related. So that is where I like to indicate certain points. I must say that the points which were mentioned through our brainstorming in the NAS, they were considered, and some of them have found place in the amendments. But there are certain areas where, as you have also indicated, that what has to be there, who has to have free access and so on. I like to say that certainly there is a need for some improvement in some definitions, which have been indicated in the presentation made by Pratibha just now. And I think the input which she has provided will be quite helpful in making clarity in the definitions, and also remove some things or bring clarity, like codified traditional knowledge. This needs to be defined, that what is it and how is it. And certainly the definition of agrobiodiversity will need reconsideration. And that is where we should indicate very clearly that this should be the definition. As far as the other part, the delegation, and this right from the first draft of the Biodiversity Act which was enacted, we had given our input that agrobiodiversity has to be treated separately. And this is a very important area of total bioresources and their utilization. And that point needs to be really underscored and highlighted, that there is need for having a separate delegation for utilization and conservation of agrobiodiversity. And the suggestions which had been given earlier, that this power under the act itself, not under delegation to be done by someone else, but under the act itself, there has to be a specific place that this will be, and this power is delegated to the secretary there or something, which is the right point at this stage. We should highlight on that. Well, sir, then see the role of ICR, as you also mentioned, also becomes very important, because PGRFA is being taken care by the Ministry of Agriculture. And that becomes the major access required for bioresources. So I think that is where this point, we should not highlight on many points, but the major areas where we feel this will make an impact is the delegation of powers for handling of agrobiodiversity. That is one thing. I also don't agree that you give free access for AYUSH practitioners. And of course, that liberty has to be at par with our national breeders also. But there has to be provision for permission from the State Biodiversity Board. Otherwise, there will be over-exploitation and exploitation of the biodiversity, and the very purpose of the act will be defeated. Rest of the points have been very amply clarified. I don't want to really repeat them. I will just summarize that there are areas where definitions will require clarity. There are certain things which need to be defined as what is codified traditional knowledge, and that needs to be very clearly mentioned. The subsection of agrobiodiversity has to be clearly mentioned and defined, and the delegation of powers has to be indicated in the amended act. There are many other things which are also important, because in some places the delegation where the role of chairman was there, it has been indicated or secretary NBA. I feel that there will be a dual, the powers working in the same organizations, and is also seriousness in the overall implementation of the act. That has been done in the delegations and other things, and authorization, signatures and everything. So this was only assigned to the chairman of the authority. Now this is chairman or secretary. Now sometimes this becomes then the dual functioning and creates problem to the organization. It's just another point, and there are many which I think this deliberation may not like to concentrate, but our main focus should be on these areas which have been flagged in the presentation, and I think they are areas where we should give more emphasis. Thank you very much for giving me opportunity, sir.
Sir, you may have to unmute yourself, please, sir.
So thank you very much for giving very clear, suggestions as to what we should do and what is our main focus today. And I would not repeat those, but I think we need to consider them in our representation which we have to make, and make a good case as to why agrobiodiversity should be treated differently, and why delegation for this to dare, and why the bidders in the national system not to be treated on par, and also why only the freedom to Ayush practitioners. I think these are some concerns I also felt, and we have to also understand what do they mean by codified traditional knowledge. We thought traditional knowledge is traditional knowledge. What is this codified? And this is confusing. And I think there is no definition of it. So we will come to it. Let us hear others, and then probably there will be more clarity. So I would now come to Dr. T.R. Sharma.
Very good morning to all. Honorable Chair of the discussion, Professor Paroda, distinguished senior mentors, colleagues, ladies and gentlemen. First of all, I would like to thank the society for inviting me to be here this morning to participate.
We have lost you, Dr. Sharma.
Biological Diversity Act 2002 and subsequent VDA rules 2004 and regulations. There are many implications which agriculture scientists has faced, and one of the most important implications was shown by Dr. Pratibha during her presentation, that there was a sharp decline in exchange of genetic resources for agriculture. So it has really impacted overall research on genetic resources for agriculture, for their collection, conservation, characterization, and genetic improvement of cultivars. We are not able to make its impact now, but it will definitely come on the surface after few years when we will try to see the results of its implications. We know that all these regulations should be made as a facilitator of the end users, not innovative in nature. And that's where this simplification of these rules and regulations are very, very important. Sir, I would like to say that DARE and ICAR participated in all the deliberations related to amendment of these NBA amendment bills from 2018 onwards, and there was represented, this ICR was represented by Dr. D.K. Yadav in all the discussions. And when I joined in 2020, I was member of GV of NBA. I think that's what they always keep DDC Crop Science as one of the members of NBA. So we had many discussions on various points, and whatever ease which you are seeing today, they have given on various issues, particularly on patent filing, patent, and also exchange of material and other issues. That was all happens because of discussions we already had earlier on this particular issues. I would like to say that there was a discussion in February 2021 with the various departments like Department of Biotechnology, Department of Science and Technology, and also Department of Agriculture Research and Education along with Agriculture, with the chairman BDA and also Ministry of Environment and Forest. There we raised 9 concerns, and those concerns were the results of all discussion which already had with NAS and also discussions which we already had with the NBPGR, Director IRI, Dr. Prabhu from PBPFRA. Those concerns we raised there. And out of those 9 concerns, 8 they immediately agreed upon, and they agreed on all those particular suggestions which we gave to them. But when the draft of revised NBA amendment bill was published few days back, then my first question was, whatever we suggested, that was really, has that been accommodated in written document or not? That was the first question, and I used to ask Dr. D.K. Yadav and also Director ISPGR and Dr. Pratibha Brahmi that we should make a list of all those issues which we suggested, raised in our previous discussions, and whether that is a part of final bill which they are now publishing or not. And that's the result of what Dr. Pratibha Brahmi has presented today. And I'm really happy to see that she made a very nice and very clear and crisp presentation. But some of the 3 issues which are raised by us and also by DARE, that the authority may constitute a committee under DARE to deal with agrobiodiversity with Secretary DARE as its chair. That has not reflected anywhere, and that's what the issue which probably we have to again stress upon. And similarly, the government institutions or public funded institutions in other countries shall be exempted of the prescribed fee meant for the access of agrobiodiversity for the purpose of research. I didn't see anything related to fee, etc. We also suggested that the deposition of novel microbial strains in the repository outside India for publication purpose. If we want to publish any paper in any peer-reviewed journal outside India, they always emphasize that the strains should be deposited with the international repositories, and that should be reflected in the NBA rules. Otherwise, we have to take permission and all those things. So that has also not, I have not seen that part somewhere addressed by in the published will. Similarly, we also, from their side, we also suggested that ICAR bureaus mandated for collection and conservation of component of agrobiodiversity should be exempted from approval of NBA or SBB. So similar to what we are talking about, Ayush and Hakim, they are exempted, but not our scientists from National Bureau of national bureaus, whether it is related to agrobiodiversity or microbial or insect or animal. We also emphasize that the nodal ministries which now created like animal husbandry and fisheries should also be figured in the NBA as one of the ministry who participated in the government of India sites, but that has also not taken place in the revised guidelines. In a nutshell, I would like to say that today's discussion would be very, very important, and we have to give only recommendations on 3 or 4 main issues which are really bothering us regarding definitions as well as authority to DARE or Secretary DARE. All those issues should be very clearly brought out, and definitely we will be submitting our response to ICR side also. ICR side also we will be submitting our response based on this discussion which we are going to have today. And it's a very timely decision, sir, which you have taken to organize this particular discussion. We will get a lot of feedback from all the participants from here, and that will make more clarity from our side what we should clearly say to NBA and to this particular committee of parliamentary committee for making amendments. So with these few words, I would like to close here, and thank you very much. Thank you all for inviting me for this particular discussion.
Yeah. Sir, would you unmute your microphones?
Thank you, Dr. Sharma, for providing all this background and also your concern to have the issues to be flagged on priority, because if we don't do it now, we will be missing the opportunity. So I think highest priority is required, and no doubt from government side, you are the key person along with Dr. Mahapatra to flag it. And we will only facilitate the process through the discussions, whatever are important issues to be deliberated and highlighted. I was seeing in the membership of the Biodiversity Committee, there is a inclusion of Indian Council of Forestry Research, but not inclusion of ICR. It is reflected as there. There is ICR has its own role, you know. And if ICR is not represented there, means who? Tomorrow Joint Secretary may represent there. We need the scientist role.
Yes, sir, that we asked there, and they told very clearly that only departments of different ministries are being considered, particularly, for example, Department of Biotechnology, Department of Science and Technology. So all departments coming within the ministry. So we emphasized that, but they didn't agree.
So we have to highlight this also, please. And we will highlight this.
Yes.
I am not saying that there should not be there. There is okay. That is a department of the ministry. But the important functionary is the council for agricultural research. It's not, we have created it, and it's the most important national system. If representative of ICR is not there, let there be also additional representative if it is required on administrative matters, you know, relating to all those issues. So this is one I just noticed. I wanted your reaction on it. And no doubt all other points you have said are very relevant, and hopefully we will be able to provide more insight into what kind of initiative or you know, immediate action to be taken at ICR and their level, which is your you know, arena. But from society side, because we are also concerned, and that's what is the role of these scientific societies. So the deliberations of today will also be flagged on behalf of society as well. So let's all work together, and maybe NAS also takes it up separately. Professor R.B. Singh, we would urge him to discuss it with Dr. Mahapatra and see that another submission goes from NAS side. And rather he and myself from TAS side, we will be making representation to this effect based on the overall deliberations that emerged today. And we would also request for our personal appearance if required, if they would like to. Because this is nut and bolt for our future. And we can't just leave it like this lightly. So let's all give high priority to it. And thank you for your joining and assuring the action to be further taken. Maybe Dr. D.K. Yadav would like to add few things because he had been attending the meetings, or if any specific point which has not been deliberated.
Thank you very much, sir. Thank you very much. And good morning to all seniors and my colleagues. Sir, in fact, this issue was actually initiated by the council earlier from 2018. Dr. Pratibha and Dr. Kuldeep Singh, they used to give the input, and the copies were coming to us, and most of the times to DSC, and they were taking care of that. So on 24th July 2020, a meeting was held by the cabinet secretary, where many of the secretaries, they gave a, I think, list of their complaints that these things under the draft which they circulated, they are not being taken care of. And in light of that, a meeting was held by the secretary there and DGICR on 1st August 2020 through virtual mode, and all our former directors and those who were concerned, based on the availability, they all attended this meeting. And based on that, the 4-5 points actually they were identified at that time, and the input was given to all those 5 points on in the same month. And sir, then later on, I was nominated as the nodal officer, and a working group was actually made, where some department secretary, joint secretaries, they were there, and this working group held 5 meetings. And the issues which we are discussing today, sir, most of those issues, They were flagged. Myself and Dr. A.K. Singh used to be there. Dr. Pratibha was also there in some of the meetings, and we used to take input from ISPGR also, sir. So regarding biological resources, sir, the initial our issue was that they have added the word information with that. So our main fight was to remove the information. So information was removed from there, but the present amendment which has been placed, so there are some modifications which Dr. Pratibha has already presented, sir. In research also, sir, that definition was changed, and we were totally, I think, helpless at that time. So again, with the discussion and all those things, the definition was agreed for keeping status quo. And we, during the first February 2021, sir, one meeting was held where the Secretary DAC, Secretary DARE, and Secretary MOEF and Chairman and NBA. So they were there in that meeting. Again, these points were raised, and many of those points were agreed. But the free access to the plant breeder, or the exempting the plant breeders from the access to any material with the condition which they were putting. So that was not agreed by the chairman, this secretary, and this Ministry of Environment, Forest and Climate Change, sir. Regarding delegation of power, sir, this issue was discussed at length, and we emphasized that it should come in the act itself. But they said no, under section 16, there is a already provision that the DARE can be made as the regulatory body for particularly for the PGR related to the agriculture and food security. So that issue was not agreed, sir. Then reciprocal exchange, sir, that issue was raised by us from very beginning, and we were discussing. And our secretary on the 11th February 2021, there was a meeting under the chairmanship of Cabinet Secretary, sir. So there also this issue was flagged, and that was in the proceedings also, that the reciprocal exchanges in the research component that should be accepted other than the collaborative research project which we are holding, sir. So, sir, now one issue which I think we have been discussing with Dr. Prabhu has already given most of the points. So the point in section 4, sir, regarding transfer of the results, and they are putting a, I think, rider on the even publications also, research papers also, so that Dr. Pratibha has already presented. So during our discussion, we could find that that is now one of the most important issue, along with the other issues which have been raised, and Dr. Gautam Saab has, I think, very clearly told that the points which we have to take, because at this stage we have to be very specific, and a very few points will go, they will be having impact from council side, as DD Saab has told, we will be taking up, sir, that from society also a very specific points which are doable also at this stage, because it is a act and in the parliament, so everything cannot be changed at this stage, which I think, sir. So with these words, sir, I think Dr. A.K. Singh was also very closely associated, so I will request the chair that he may also be, I think, heard, sir, on this issue. Thank you very much, sir.
Okay, I think again appreciate for all the background, all the background which you have provided, Dr. Yadav, and the concerns that are there. And certainly I will request also Dr. A.K. Singh. But one point which has come up, and Dr. T.R. Sharma also said earlier, that we have to highlight that who is the gainer by putting more of these restrictions in the terms of exchange. Earlier, the slide which was shown by Pratibha was for the export. That export had declined after the BDA. But I would say import had also declined. And our interest in the national context is more of the germplasm to come to India, which we don't still have. And our food basket would have been different if there ever had not been exchanges in the past of good, crops, varieties, species from abroad. So it is not because when you say we are not able to export, then they will say, oh, you want to give to the others. So the connotation will be different. Here we have to flag it differently, that unless you give, you don't get, but you are not getting, and you do need still for your future growth, valuable materials, germplasm from rest of the world. So that part, I think we will try to also highlight in our, and you may consider that in your representation as well. Could I request then Dr. AK Singh, please. We appreciate that you are also able to join. Thank you. And
thank you, sir. Thank you very much for the time given to me. I would only like to reiterate on the 2 points. One is the freedom to use the plant genetic resources by breeders, particularly in the public sector. Now, you see, many times I find that our confusion comes because either we are not able to properly interpret, or we are wrongly interpreting, or there is need to deeply understand what is written there. So I think in light of that, we need to analyze. I was discussing Dr. Prabhu yesterday, and he said that the definition which is given in the preamble of any act, it supersedes the subsequent notings that come in. Now, if we go by that, the definition of the commercial utilization in the 2002 Act, and primarily this one 2021 is amendment. The main body remains as it is there. So now if we see the commercial utilization definition, which is there in 2002, and then from that I may take little more time. And from that I would like to understand, are we really restricted? This says commercial utilization means end uses of biological resources for commercial utilization, such as drugs, industrial enzyme, food flavors, fragrance, cosmetics, emulsifiers, oleoresins, colors, extracts, and genes used for improving crops and livestock through genetic intervention. So this is the genetic engineering part, but does not include conventional breeding or traditional practices in use in any agriculture, horticulture, poultry, dairy farming, animal husbandry, or beekeeping. So traditional breeding is already exempted as per definition of commercial application. So where are we getting restricted is the question I'm asking. Now, let us go to the section 7 of the 2002. Section 7 of the 2002 says, no person who is citizen of India or a body corporate, association or organization, which includes all of us. It exempts those who are covered under 3.2, and 3.2 is foreign nationals, NRIs, and company with foreign equity. So it is not talking about that. It is talking about Indians basically. No person who is citizen of India or a body corporate, association or organization which is registered in India shall obtain any biological resource for commercial utilization or biosurvey and bioutilization for commercial utilization except after giving prior intimation to the state biodiversity board concerned. Now here a statement was made by Dr. P.L. Gautam that we must take state biodiversity authority into account. Seeking permission is nothing bad. This was said. Now, is that a restriction? However, from that permission, provided that the provisions of this section shall not apply to local people, communities of the area, including growers and cultivators of biodiversity, bads, hakims, who have been practicing indigenous medicine. Now, do we want to be at par with this category, that the public sector plant breeders should not be asked even to go to state biodiversity authority. Otherwise, nobody is restricting. Number one. Number two, if commercial definition supersedes in the preamble, then this becomes null and void. It becomes irrelevant. Now, come to the modification that has been brought to section 7 in the 2021 Act. This says only the words have changed. The meaning remains the same. It says no person other than the person covered under subsection 2 of section 3. That means Indians, because those who are covered under 3.2, they are not Indians. They are either foreign nationals, they are NRIs, or companies with foreign equities. So it says no person other than person covered under subsection 2 of section 3 shall access any biological resource for its associated knowledge for commercial utilization without giving prior intimation to the concerned state biodiversity board. So this is exactly what it was 20 years back in 2002. Where is the difference? I don't find. When it was accepted by us for last 20 years, where is the problem now coming? So I think there is something between the line that we need to read and then understand. In that context, we should put up our proposal. Otherwise, we will be on the receiving end. Now, the third point, when I talk about the research issues, which Dr. Yadav mentioned, and Dr. Prabhu has also highlighted in his presentation. And this is from the 2021, and that comes on page number 3. And this is restricting, but if you see the context also on the right-hand side, it reads that results of research not to be transferred to certain person without approval of the National Biodiversity Authority. And who are those certain person is defined. Those certain person are the person belonging to section 3(2). That is NRI, foreign nationals, and companies with foreign equity. Only those 3 are covered in this. Now it says, no person or entity shall share or transfer any result of research on any biological resource occurring in or obtained or accessed from India or associated traditional knowledge thereto for monetary consideration or otherwise to a person referred in subsection 2 of section 3. So means the Indian researcher cannot transfer any knowledge, research, finding, etc. to those belonging to subsection 2 of 3 without prior written approval of the National Biodiversity Authority, except codified traditional knowledge, which is only for Indian. Then next it says, provided that the provision of this act shall not apply if publication of research paper or dissemination of knowledge in any seminar or workshop involving financial benefit is as per the guidelines issued by central government. We have been attending so many seminars, symposium, conference, national, international, and after taking the approval from there, we were presenting result findings and everything as it was done earlier. So that is what it is said here. But what is restricting here is that provided further that where the result of research are used for further research, then the registration with National Biodiversity Authority shall be necessary. This is restricting for doing research. Even for doing research on a published paper, if you want to do further research, whether in India or outside India, of course, the context here is only with respect to those 3 categories of Indians, 3 categories of people, not with respect to India. So if we read in line of that, then Indian researchers are not restricted to do research on the findings of research that is already existing. However, then further it says, provided also that if the results of research are used for commercial utilization or for obtaining any intellectual property rights within or outside India, prior approval of the National Biodiversity Authority shall be required to be taken in accordance with the provisions of this Act, which is fair enough. If somebody is taking IP outside, and these are basically the category of people, 3 category of people, if they are taking patent outside or in India and they are going for commercialization, then prior approval from NBA will be necessary. So I think there is, a deeper discussion required and understand the meaning line by line. What is the implication before we put it in writing and represent? Thank you, sir.
I think appreciate very much further clarity and insight in terms of maybe there are catches somewhere in one clause which is to be understood relating to the other clause. So what you have said is appropriate, that if there are certain concerns, as we have earlier discussed about change in definition or clarity, then those should be taken into account after clearly understanding what are the implications which are already in the existing clauses. And if they are covered, then probably no need to highlight. But maybe further clarity on that, if can come in, will be desirable. I mean, one is that you read in between line and try to extrapolate. And the other is have clear understanding, like, they have said delegation is there. So they will say, we will give delegation. you request for it, but why not have clear delegation for DARE here and ICR for the agrobiodiversity? And why not, when you are defining agrobiodiversity, then who is going to handle the agrobiodiversity? So I think we need to possibly, as you mentioned, and I would urge you, no doubt you are quite busy otherwise, but your insight into this, along with Dr. Prabhu, and a smaller group can then look into when we have come out with our submission and see whether what we are asking is right or not. And we should just simply not ask for something if it is already there. It's very clear. Thank you, Ashok, for it. We appreciate, and I hope you will be able to be there for a few more minutes. So with this input, now I come to our colleagues from the Bureau. They would like to give their input, and I think I see Dr. Dillo, Dr. Professor Sharma, then also I see Dr. Sandhu, whether they would like to make any specific additional points. I mean, rather than what we have already deliberated and discussed. And then maybe Dr. Karyalu, Bhagmal, they would like to say something. But we need not also make this meeting longer than, say, another 40 minutes, which means we should close by 1. So we have 40 minutes, and I'm sure everyone can, who's over participating, can give their input. Just take 4 to 5 minutes each. But we will need Dr. R.B. Singh then to really crystallize and give his viewpoint, which I am still holding because I know he is the best synthesizer in terms of deliberation. So we will request him to sum up before we end. Anyone please volunteer and
yes, sir. Sir, can I make 2 quick points?
Yeah, Dr. Sharma.
Yes. Thank you, sir, for giving me an opportunity. Sir, one point is that in the section 8, there are 16 ex-officio members. And as Dr. T.R. Sharma also mentioned, that the representative from the Ministry of Fisheries, Animal Husbandry and Dairying has to be there. And also representative from the Ministry of Commerce and Industry, because all IP issues are with the Ministry of Commerce, as I understand. So, and surprisingly, there are 3 members from one ministry, the MOEFSC, the Ministry of Environment, Forest, Climate Change. So probably this need a little bit of rationalization. The second point is that in the section 2, as it has been said, the definition of biological resources needs changes, particularly the inclusion of DSI and the omics databases. We discussed this issue earlier also. So probably this has to be taken care of when we define these biological resources, because these acts are not amended frequently, and the area of DSI omics, it's gaining a lot of importance, and therefore this should also be taken into consideration while we define the biological resources in the Act. Thank you, sir.
Thank you very much, Dr. Sharma, for being so clear and very specific in terms of additional points and suggestions. And could I request maybe Dr. Dillo has any point, or I came to learn through the deliberations. Dr. Ram Chaudhary also wanted to say something or input, but we'll come to you, Dr. Ram Chaudhary, after Dr. Dillo and Dr. Sandhu, if they have to add something.
Yes, sir. Good morning. Thank you very much. I will not take much time. I could not read the material. I will send my detailed comments.
Hello.
Hello, am I audible or not?
Thanks, Dr. Paroda.
You are audible, sir, Dr. Dillon.
Yeah, Dr. Chaudhary, please wait after Dr. Dillo and Sandhu.
Okay.
We'll come to you.
So I will just touch maybe 1 minute or 2 minutes. I will touch some points which come up today during discussion. First of all, thanks to Ashok for minutely going through. But Ashok, whenever there is contradiction, we should say that it should not be there. Because our Indian outlook is that we always look at the negative side. So better, there is no contradiction. Secondly, about publication. If I publish something in some journal, how I can say somebody who want to use those results, that he should take permission, I have to take permission, or the person who is using that permission, that knowledge, he has to take permission, who will be the responsible. Then when we talk of this, that DBT is there, or other departments are there, when we talk of agrobiodiversity or biodiversity, I will say agriculture is much, ICR is much more important than other ministries or other, in addition to ICR, in addition to DBT, as they said there, ICR should be there. Then another point which came to my mind that probably it has not discussed. We have some private seed companies where there are foreign stakeholders, and we have common trials. What will the implication for those ACRIP trials where there are private companies, where there is stake of foreign stakeholders? And one suggestion from DK Yadav, he is very practical, said doable. I will say, let us not worry about doable. Whatever is correct, we should say. Then let us leave it to the other. At the moment, only this much, sir, I could not go through because of certain reasons. I will send detailed comments by tomorrow evening to you, to Anuradha and Brahmi. Maybe if anyone else needs, I will send to him once. Thank you very much.
Thank you. Thank you, Dr. Dillo. We appreciate, and again, very clear and specific, and glad that you will be sending comments. So we look forward to receiving those. Then I come to Dr. Sandhu, please. Dr. Rana was also requested, Dr. Rai Singh Rana, but I think he is also busy somewhere, could not join. So among the directors, we have Dr. Gautam, Dr. Dillo, and Dr. Sharma, and I include myself also among the directors.
Of course, sir, very much.
If you agree, yes.
We very much agree.
So,
is there any alternative, sir?
What about Sandhu? He's not there?
He was there in the beginning, sir. Let me see.
Okay, maybe he has left. So, maybe Dr. Ram Chaudhary, could you come?
Thanks, Dr. Paroda. I think giving me an opportunity. In the previous version, and also in the current one, which is now muted, I don't see any provision of punitive action. If someone doesn't behave, if someone without authorization exports the genetic material, what happens to that? So I think there should be some clause added to it, and I can cite a case. Now, Kalanamak rice is a GI variety. Someone from Japan, he's Indian, in fact, settled in Japan. He said he's going to multiply it and make it commercially available in Japan. I wrote DGICR. I wrote the chairman of the NBA, and also to director of IIRR, also to director of NBPGR. Response came only denial, that I have not issued any permit for taking this material outside. NBA is sitting quiet, 4 reminders, no response from them. So at least if such cases happen, what will happen? So I think there should be some clause for the punitive action. That's all, sir.
Okay. Thank you, Dr. Chaudhary. And we appreciate you are supporting and popularizing Kala Namak. Even I am beneficiary of that. Thank you.
Yeah.
and your efforts are all very much recognized. So I now come to our other colleagues. Kindly, rather than I invite, please raise your voice or hand, and let's go ahead, because there is a provision here for raising your hand. And yeah, okay, Dr. Bhagmal, please.
Thank you, sir. First of all, I am grateful to ISPGR for providing me this opportunity to be present here in this important meeting. I have only 2-3 points to make at this moment. First is, as has already been said, that there is a lot of confusion about certain terms in the Biodiversity Act, which needs clarification. For example, harmonization between the two acts is very much needed for variety, for folk variety, for farmers variety, for biological resources, for agrobiodiversity. Which is not that, as a result of which there is a lot of confusion at several times. Second part is that from the ICR point of view and the food and nutrition point of view, the major responsibility of plant genetic resources, all aspects of plant genetic resources, including collecting, characterization, utilization of germplasm, has to be there. It is to be dealt with in totality, and there should be a clear-cut mention in the Biodiversity Act and the rules that who is the responsible organization for this. In fact, NBPGR, it had been raised every time whenever there were such meetings and interactions that NBPGR should be given the sole responsibility, which is not happening. Now, in fact, this is a major point which we must focus, that there ICR and NBPGR should be made responsible for this, and the power delegation of power should be made accordingly. Thirdly, we know that exchange, at one time there used to be a lot of exchange through international nurseries of rice and wheat, and India also used to give a lot of material. Now it has been definitely declined to a very great extent. So unless we get material from outside, how we can make our plant breeders can make use to develop better varieties. So this aspect has to be very clearly dealt with. Thirdly, in the biodiversity rules, the note which was circulated by Dr. Pratibha Brahmi, close by close, there are a few points which, of course, need consideration. In one of the sections, section 32C, there is a mention of foreign controlled company. That is not clear. I mean, it needs more clarification. In section 4, there is a mention about monetary consideration or otherwise. What is that otherwise? That part is not at all clear. I mean, this is subject to making any kind of foul play there when we say monetary consideration or otherwise. So this has to be clearly rectified. Thirdly, in section 7.2, issuing certificate of origin of medicinal plants, there is a mention about medicinal plants. And since Ayush Ministry is there and Ayush practitioner, there is some clause. I think along with medicinal plants, we should also mention aromatic plants, which is missing from this one, because aromatic plants are also used in medicine. Another important point is that the state biodiversity boards, I'm not sure whether these boards are available in all the states. In fact, they are important functioning, and it should be ensured that every state must have one state biodiversity board. And at one place it is written in clause 22 that application in such form and in such manner as may be prescribed to National Biodiversity Authority. This is very, very confusing. It said it should not be prescribed to, rather it should be prescribed by National Biodiversity Authority. So these are some kind of editorial mistakes which have to be also rectified. And in section 21.1, it is mentioned that Biodiversity Management Committee represented by NBA. This should be otherwise. I mean, National Biodiversity Authority is a bigger organization than the Biodiversity Management Committees. Committees function under the purview of NBA. So this should be that Biodiversity Management Committee should not be represented by NBA, rather NBA should be represented by Biodiversity Management Committee in whatever context it has been. These are some of my views. Thank you, sir.
Thank you, Dr. Bhagmal. Again, appreciate. Now I think there is a division of responsibility. The rest of the discussion, I would request my honorable senior brother R.B. Bhai to take over and maybe conduct the remaining proceedings for further discussion and conclusions at the end. So I request you, R.B. Bhai, please.
Sir, kindly
You have
unmute your microphone, sir.
You have to unmute, please.
Am I unmuted now?
Yes, sir, you are audible, sir, very much.
Okay, thank you so much. Well, thank you, Rajendra Bhai, for your wonderful initiative. ISPGR, I congratulate both of you for the wonderful and timely organization of this meeting and giving me the opportunity to be present here to learn something together. As a matter of fact, when many of these rules were being formulated, I was based in Rome, and the International Board for Plant Genetic Resources, as well as you probably know the various developments of the related issues to farmers' rights originated from the FAO discussions in those days, and in some way I was connected with that. So I'm so glad to refresh some of those things. And still, I would like to mention that the Principal Act, which came actually in 2002, has been a profound act, and it came at the right time through the initiative of many of those activities which were undertaken. Of course, when we further started looking into it, the Nagoya Protocol came, the CBD Nagoya Protocol all taken together, of course, closed what we call the free global process of genetic resources exchange. And then it became the shared responsibility of the national systems. And so the national systems became very important so that the principles of fair and equitable benefit sharing could be really realized, and the farmers' rights came into play at that time. So I would underline this thing, that besides the conservation and so on and so forth, what became important is fair and the equitable benefit sharing arising out of the use of the genetic resources. And this was a very major breakthrough and development, and we should not deny this at any stage by any means. So keep this centrality of the initiative of this Principal Act, which is very, very important for the humanity, and particularly for the poor and the smallholder farmers, and farmers, primarily the tribals who are poor. Now, when we really brought this treasure under the national control, the treasure of genetic resources under the national control, and the resources to be managed, so then the responsibility of the individual nations also increases tremendously. And therefore, I will say that it's very important that we keep looking at what is happening at the international and national level to liberate again the system so that there could be free availability of genetic resources. I do not say free, unquote, and quote unquote, free does not mean we are talking of the economic free or so on and so forth. But I say if it is needed by a researcher, it should be available, and what should be the way that we can facilitate this to happen, it should be brought into play. So I think the anomalies which arose because of this tight control of the national systems and the IPR systems and so on and so forth, which resulted into many of the tightenings, have to be looked into more carefully, and many of the confusing words which have come in the process should be taken note of. So I will feel that the national responsibility at this stage has increased. And therefore, if we have in our country like NBA, PPV, FRA, the ICR system, and so on, they all have to look into it together. And we cannot work it separately. We all have to be working together to make it sure that there is no confusion or duplication. So the amendments which are being talked of today in the 21 have to be based on, of course, the objectives and the issues which were very clearly mentioned by Pratibha. We fully agree with that and we honor it. But then at this stage, I would only like to mention that when Dr. Gautam, we had requested from NAS to convene a meeting on these various issues which were bothering us, a policy NAS document came, as you all know, and as it was reflected and shown. We kept trying and we kept trying, and we felt that it is not being respected. And TAS similarly has been trying, and we feel that many of the things have not been respected and not been implemented. We will urge many of the things that we have brought out in the NAS or TAS or earlier publications should be taken care of. Likewise, the PPB, FR, and the NBA separately, individually, has come out with many things. So I will say that if today, of course, the 5 directors of NBPGR outstanding work that they have done, and the kind of facilities they have provided at the system to look at many of the wrong things which happened. Today, of course, brinjal rice is grown in Fatehabad. BT brinjal is in Fatehabad. And adjoining areas, who brought them, how it came, is it the same BT brinjal that went from India to Bengal, came back, or is it something different BT brinjal, or what is happening? So is our biodiversity being polluted, or by many of these things which are happening, nobody is taking note of it? Of course, NBPGR is taking note of it, but then who is listening to it? But then the implementation part of it is becoming lost. And so golden rice many a times, various kinds of imports here, there. In Maharashtra, one or other introductions of one or the other kinds have taken place. So my submission is, a point was also made, not only import or export, but also Kala Namak was mentioned. If something is wrong happening, who is responsible? So I think we have to tighten the rules, regulations, implementation schedule, and also the responsibility and accountability in a differentiated manner, which has not happened. And so we must take a differentiated responsibility, accountability, and action. Accountability means action, and that has to be brought into play. Otherwise, this brinjal bag, BT brinjal of all kinds will come. We'll get all kinds of golden rices and all kinds of introductions, and many of your wonderful things will be taken away and you will not be aware of it. So I will feel that we need provisions to control such incidences in a very important and tight manner. My submission is that we recently held meetings of the Food Authority of India, the Safety Management and Control, K.C. Bansal, who was also the earlier director of NBPGR, and one of your very distinguished scientists, Anuradha, our Randhawa, she came into this discussion, and I think they have come up with the kind of duplications here and there, and how should we be able to internalize many of those. It is Gurmeet Jeet, isn't it? Gurmeet Jeet Randhawa, that is her name probably. Yes, Gurmeet Jeet. The good work that they are doing there at NBPGR and the wonderful contributions they are making. If they all get together to see that Dr. Prabhu, as I mentioned, Dr. Prabhu, only 2 weeks ago, he talked to me and also shared with me about a month ago some action that he had taken it from the PPVFR for allowing the farmers to get their which they are not getting because of wrong interpretation and wrongdoings of some of the systems and the people involved in the process. Now, therefore, all the points which Dr. Prabhu has mentioned, I would very strongly urge that the farmers' rights should not be taken lightly, and the points which Dr. Prabhu mentioned should take a lead, as a matter of fact, in sharing our genetic resources, making use of land races. Land races are much more important than any other genetic resource, as a matter of fact, because their genetic alchemy has passed through the various tests, and they are being held there because they were needed and they are important. Likewise, so I will feel that all those statements made in the farmers' rights committees and the provisions made there should be taken note of. And we bring together, of course, Dr. Gautam has chaired both the NBA and PPB FRA. He knows both sides. But I think what we really need, the NBA, PPB, FR, and FASI, FASSI bills, and so on and so forth, many things are common in them. Many things are common in them, but they are all working independently. I think they have to work together. They have to be in cohesion. They have to be harmonized. And we cannot have several acts to suit several kinds of conveniences. We have to have a national system. Nation is important. The nation's people are important. And these harmonizations, cohesion, convergence, congruence should be synergy, should be based on science. And if science is working there, then that will bring you together. And the scientific considerations should be able to bring us together. And therefore, for example, the folk variety. What is folk variety? As a matter of fact, it's so confusing. The farmer's variety and folk variety. I think to dilute the issues, there is no place for this. To take it synonymously or giving importance to folk over the farmer's variety, it doesn't make sense. And similarly, as I mentioned, the land races, the tremendous importance of this and their release as a variety, and many of them could be the mega varieties in real sense, actually, because of their adaptability and their resilience and so on and so forth. Agrobiodiversity then automatically comes into focus. I will say that there is a special case. Agrobiodiversity will serve the agriculture transformation to build new India. And if we lump agrobiodiversity together with all kinds of things where we have no control, and therefore ICR should come into the main focus to be totally responsible for the agrobiodiversity and play the leading role. I mean, ICR cannot be a helpless spectator. ICR has to openly come out and take the responsibility and say, it belongs to me, I will lead it, and I will harmonize the things together based on science. Because the research without genetic resources, without the genetic variability, availability of the right kind at the right place is absolutely essential. And therefore, it's conservation, it is the characterization, it is the utilization, it is the sharing, conservation through utilization. These are all parts which are with the ICR, and therefore the recommendations of NAS, TAS, and the follow-up activities that we have undertaken. Today, a point was made, CGIR is not the same. It is one CGIR we talked about. We talked about the exchange of genetic resources in the beginning, which was being done through the CG system. Is it being done the same way today? No, it's not being done. Are the national programs with the CG system the same way getting the benefit? Vice versa? No. So I think it is the high time. Today we have one CGIR. Today, if we have one India, one system to really interact with one CGIR system, see how the pre-breeding work today is so very important, particularly for getting the benefit of the genetic resources. So the pre-breeding work has to be strengthened. And who will do it? ICR will do it. and ICR will have to take the lead. Dr. T.R. Sharma has to take the lead, and probably we have to get those things going. So I will feel very strongly with the importance of pre-breeding, with the change of the CGIR, with the ICR and NAR systems should also change, and our roles in genetic resources conservation and sharing increases. National program increases. And therefore the NBPGR will have to play a very important leading role in this total process. I will say clean the unclear. Must we clean the system? So many unclear words are mentioned in this revised amended bill. And I think those words Ashok, Dr. Ashok Singh, the director of IRI, many of the internal confusions in these statements which are there has to be ironed out. And we must do that. And I'm so glad, Mr. Chairman, that we wanted Ashok to create a committee and to really go with Pratibha and others together to look into those individual words and clean those controversial, unclear, unspoken words to build a horizontal as well as vertical collaboration, which is based on science, clear facts. Nothing is hidden. Nothing is clouded. And this is what I find. Many words are clouded in the statements. And even if needed, the editorial mistakes, if Bhagmal can be also associated with this, the to or from words make a lot of difference. And I think those will be needed to liberate many of these activities. So I will stop here, sir, and only say that the clear-cut collaboration at the national level, we have the national authority, we have the state authorities, we have the local level biodiversity authorities. So all these three have to work in cohesion, harmonized way, and there should be a free flow of information and acting together so that we can build one system for one India, one health, one world. And I think this will bring into the international collaboration. International collaboration in genetic resources sharing has today come to a very poor situation. Now, if we set our home right from local to global and global to local system, and we start from the panchayat level, our systems in panchayat level for biodiversity, to our state level, to our national levels, and then to international levels, we work together through this coherence with the system. So we'll be on the same page. The world will be on the same page to save the treasure, which is so invaluable. There is no treasure much more invaluable than the genetic resources. Genetic resources is life. If seed is life, genetic resource is life. And give that importance, the system must give genetic resources that importance. And if that importance comes, any rule can be clear and humanized. Humanize the rule. Okay, I think this is important. Just humanize the rule by science. That's it. Thank you, sir. Thank you for your patience.
Thank you, R.B. Bhai, for your words of wisdom and so, emotionally highlighting. We know from those IBPGR days, your involvement and then with FAO on genetic resources. And till today, we are very appreciative and thank you for all these good, valuable suggestions. I'm sure we will take note of those. And the philosophy behind use of these for benefit to humankind is obviously understood. Now, we have few more comments. And I see Narayanan Kotaram raising hand, then Dr. Varaprasad, and then Dr. Tarihalu. So would you kindly take few minutes each and then briefly add your viewpoints, please?
Sure, Professor Paroda, this is Narayan here. I think nobody can question the intent or the need for the Biodiversity Act, but it's the implementation and interpretation where we have met some challenges. And I am cognizant of the time limitation, so I'm not getting into too much detail. I agree with all the comments that was made on fine-tuning the definitions, categorizing properly agri biodiversity versus endangered biodiversity and stuff like that. I would just limit myself to making a larger point. Over the last several years, we have seen that the real line between academic and applied, or if you want to call it research for public good and commercial research, this line is kind of getting fuzzy. And the Chinese wall, which used to be there between these two, is kind of dissolving. There are many, many instances in the ICR system, in the public systems of research where there are joint activities happening and a seamless connectivity is trying to be built. And I think the private industry is now also being seen increasingly as a very valuable partner in reaching the benefits of research in its deployment to the ultimate. So when you talk about, because there is a categorization in this act about, we all discussed that also, about basic research and research for public good versus commercial research. There are nuances to it. I can understand if there is a direct commercial exploitation of a forest produce or something that's endangered directly to make a product, that's direct commercialization. But many times, if it's a discovery leading to a product concept, leading to a development, and finally something that can be deployed, which has to be obviously commercialized for the public good to really become a public good. I think those nuances needs to be factored into this act. Otherwise, if we are still having this act sitting in the era where you had, at least in our country, this kind of very distinct differentiation between public good research and commercial research, I think it will be an anachronistic situation. I will refrain from giving you specific recommendation. I will write that and then send it to you, Professor Baroda. But I just wanted to highlight this act, and I hope most of you will agree with me. Thank you.
Thank you, sir. I'm Varaprasad. Thank you for this opportunity. I just had 2 points. So one of the partly is addressed by Dr. Narayanan, and that is 2 points. One point is conventional breeding. Second point is public good. This conventional breeding, we are now amending this act after 20 years. Next amendment may come after 20 years, or when it will come, we don't know. So the conventional breeding itself, in my opinion, should not be, that word conventional should be removed. Any breeding approach for research purpose, whether it is public or private, should be done. Then when it comes to commercialization, and section 3.2, I have absolutely nothing against it. Section 3.2 is fine. But in breeding, why restrict to conventional breeding? It can be any breeding approach for crop improvement in the form of research, whether it is a public or private, in my opinion, should not be restricted, including the patents. Even patents, as all of you know, 80% of the patents are not commercialized. So the entry of the MBA will come when commercialized. For research purpose, there should not be any restriction, whether it is public or private, or any breeding method that is adopted now or in future. That's one point. Sir, second point is, the FAO has designated all germplasm collected prior to 1993. There are several international gene banks, even other than CG gene banks like World Vegetable Center or others, who has the material collected after 93. So that if that belongs to India, whether you access it within India, occurring in India, or maybe even from outside National Gene Bank also needs to be addressed, that if our material collected after 93 and it is not FAO designated and it is being commercialized, again, I want to say that for research purpose, no restriction, but for commercialization, the NBA should take it. And last comment is, in case of the germplasm exchange, there was in 2003 when plant quarantine order came, Director NBPGR was legally allowed to issue the import permits, the phytosanitary certificates, all germplasm used for research purpose. And why not agrobiodiversity for research purpose should be handled by the Director General, ISPGR. That's it, sir. Thank you very much for this opportunity.
Thank you. Thank you. Appreciate your input as well. And also Narayan Kottayam also. We look forward to have additional support in terms of written statement. If you would like to send, we will appreciate. And now I go to Dr. Karyalu and then Dr. Jay Rana. I see also raising his hand.
Thank you, sir. Thank you. Thank you, sir. Thank you for giving me this opportunity. In fact, I agree with all my colleagues, particularly who have had an experience with dealing with plant genetic resources with respect to the comments they made about the need for facilitating utilization of the germplasm, whether it is an indigenous germplasm or the germplasm that we need to get from foreign resources for our crop improvement purposes. I would, while acknowledging that there is a large scope for redrafting some of the paragraphs and clarifying the definitions with regard to different components of plant genetic resources. Certainly, I also feel that there is a need for that. I would also like to suggest taking a positive attitude because the leeway that has been given to medicinal and aromatic plants and Ayush related plants, we should use that opening to make a case for agricultural related plant genetic resources to give us a similar freedom of operation with respect to exchange of germplasm, with respect to utilization of germplasm, and to an extent to which it is provided to us, commercialization of the germplasm. And I agree with some of the experts who said there is now a transition between research, commercialization in public sector, commercialization in private sector. They are very closely linked with each other. So we must make a case, given the freedom that has been given to the medicinal aromatic plants, based on that, build a case to give the plant genetic resources, agriculture-related plant genetic resources community, the freedom to operate for research and commercial purposes. Thank you, sir. That was my.
I think, again, good point. I had also earlier raised that why only Ayush? Why not also the farmers and the breeders who are using genetic resources for our food and nutrition security? Why only medicinal security or health security? So we have to argue on that count, and thanks for your flagging it again, Dr. Karyalu. Now I go to Dr. Rana, please.
Thank you, sir. Thank you for giving me this opportunity. Although this issue has been already flagged and Dr. R.B. Singh already mentioned that the role of CG Center. So while working in CG Center, I can see that we are working across the country and there is a lot of potential for importing the germplasm and exporting as well. But most of the country, they agree in the bilateral exchange. So already provision is there that if project is approved by the government of India, the exchange can be made. But there are larger scope of bilateral exchange of germplasm where and direct NPPs are authorized to issue an import permit. But when the other country, they ask for germplasm, we have to follow the whole process of NBA. And we are finding it very difficult to get the germplasm of other countries. So I think there should be a different provision for bilateral exchange, even if it is not a project approved by the government of India. So that should go on by different rule, I think, rather than the existing rules. So this is just my submission. Thank you, sir.
Again, I think we need to consider. So I don't see any other hand being raised. Okay, Umesh. Yes, please.
Unmute your microphone, sir.
Thank you very much, sir, for giving me the opportunity to speak. I will point out only 2-3 points. It has been very rightly pointed out by Dr. R.B. Singh that that we have to clean the unclear things. For example, definitions, so many definitions, the codified traditional knowledge. That it can be revised as traditional knowledge, which is in some systematic structural form in which knowledge is ordered, classified, organized, categorized in some manner. And not codified means oral tradition. What will we do for that? That is also very much in the community. That is also to be taken care. For the on the section 7, I would say that bill prioritizes commercial trade at the cost of conserving biological resources. This is a very important point, and there was not a single provision in the proposed amendment to protect, conserve, or increase the stake of local communities in the sustainable use and conservation of biodiversity. So this bill will undo all the efforts made in the last few years to implement the BDA. I would say that while there should be no objection for any quarters or the provision regarding fast tracking of research, there is a need to bring back the focus on protecting the interest of local communities and sharing the profit with them. The main focus of the legislation should be to protect India's rich biodiversity and associated knowledge, check biopiracy, and protect biological diversity and local growers through a 3-tier system of central and state boards and local bodies. However, this new bill clearly favors only Ayush. It has been discussed so much. Why not it should be extended to others also? This is a very important point to make it. And one more point, that for the definitions, we have seen that the BDA and the PPB-FRA, they have defined the definition of this so many definitions in different ways. There should be some coordination. One definition there should be one perfect definition. It should reflect in both the acts and both the things. Thank you very much, sir.
Thank you. I think point of harmonization had come and was flagged also by Professor R.B. Singh before between the two acts, and I'm glad based on discussion that I had with Dr. Prabhu, at least the farmers' varieties are now going to be exempted from the purview of NBA and brought under the umbrella of Plant Variety Protection Act. So if that kind of delegation is being given and agreed, which seemed to have been agreed in the amended draft, then I think delegation to their ICR through its bureau, I don't say only NBPGR, there are animal and fish genetic resources. So we are talking about biodiversity, agrobiodiversity. It's not only plant alone. So through bureau, that responsibility should be defined and given and agreed to in the amendment itself. So I think that's more critical and important point which has emerged, and probably we need to flag very clearly, highlighting why it is. I mean, anybody would ask, why you want this? There is delegation, you ask for it, we'll give it. So that is the typical bureaucratic reply. But here we have to argue and also say that when it is Ayush, yeah, okay, I'll come to you, okay. And when it is freedom being given to practicing the medicinal sector, then why not agricultural sector? So these are the issues. AK, I see you raising hand. which is
No,
more
sir, I
important.
just wanted to little substantiate that it is not only farmers' varieties. The agreement is that all the varieties which are protected with PPBFRA, whether they are breeders' bred variety or farmers' variety, the protected variety with PPBFRA will not be regulated by NBA in any context. So they are all given freedom.
So that's good clarification. But in fact, maybe what I read was the farmers' variety. So maybe we have to clearly also look at the draft again, as AK said, and if it is there, it is again very good, in right direction. And that's the kind of harmonization also is needed. And we have the responsibility, because nobody is talking about Seed Act. We have been operating under Seed Act for, breeding, releasing, notifying the varieties. And that is the responsibility of the ministry. So the Biological Diversity Act is not to recognize at all the efforts of the other ministries. And if there are acts and already commercialization happening through a system agreed by the government, then why delegation for that responsibility is not given to ministry, and through ministry to DARE and to Bureau and ICR. So I think this is an important point. I hope, Ashok, you will try to look at the draft. So I'm now suggesting, rather than, unless somebody has any burning point to add, otherwise we have already exceeded our time limit. So I'm going to suggest that we have a small, working group. It's not a big exercise to be done. Drafting a letter and attaching what we want and justification. So Pratibha has already made presentation in the beginning. Issues are flagged. We have discussed them very clearly. So I would say that let Pratibha, Anuradha and Sunil from Bureau be the nodal persons, and they interact with Dr. AK Singh, Dr. Prabhu, Dr. Bhagmal and Dr. Yadav. I hope Dr. Yadav would agree to it from the viewpoint from the ICR side, whatever are there, if something is lacking. And we need to prepare a very comprehensive, maybe 2-page note rather than too long, and make some attachments with it, justifying. And issues are the delegation of responsibility for agrobiodiversity. Issue is also very clear in terms of harmonization with Seed Act under the ministry, which seem to be not clearly understood and recognized. And where there are provisions, and we have been working all through, and issue relating to exchange in terms of not only the export, but our concern is to get more import. And therefore, those need to be looked at, and refinement of definitions. And I think AK would help us further clarifying, and maybe they are implied, Ashok, but if we can have more clarity, will be much better. Because everyone will not have that kind of knowledge and understanding that this implies there, so why you are asking this? Or maybe we need clarification, or make there more clarity if there is requirement. So that is another part. And I could see that we have to highlight Nagoya Protocol, which was not there when we came out with the Biodiversity Act. It came later on, and under Nagoya Protocol, the bilateral exchanges is very important. And in that context, again, responsibility of ICR, and exchange generally is for those materials which are good for food and agriculture, as under the TT of FAO. So those exchanges have to be taken care of, but FAO TT only takes care of multilateral But for bilateral, then we have to have a system, and that bilateral has to be between countries. And if we need somebody to import good material of, say, almond from Uzbekistan, then our bilateral partnership will be with Uzbekistan, and we should get that under Nagoya Protocol, which is agreeable and which is covering this bilateral exchanges. So, and access and benefit sharing obviously is an important point which Dr. Professor R.B. Singh also had highlighted. So I see that these are some important points which need to be considered and flagged, and we have discussed most of those issues quite clearly. And I do hope that we can come out in next next week. I think now it is 22nd, so maybe by 25th or 26th, if this draft and attachment could be there, it can be then made available to ICR. It can be made available to the president and past president of NAS. It will be also available to TAS and also ISPGR, and maybe Society on Plant Breeding and Genetics could also take it up, because more the representations go, better it is in their own form. But basically, let's move forward and not miss this opportunity. And maybe NAS and TAS could make a request to have personal appearance if joint committee would want, because they have mentioned in that notification those who would like to appear in person may indicate. They may invite us or not is separate issue, but in the letter it could be reflected at the end. So are you?
Just can I add one more point?
Please.
Yes, sir. For our justification, when we are asking for delegation to DARE, we should also emphasize that we are well prepared and we are already practicing like the bilateral MTA, which was developed in consultation with NBA itself.
For,
so we are already
for many
used.
years, and
Yes,
for many years, and we have very strong national system.
Yes,
No country
yes.
has so many bureau as we
Yes.
have.
So we should emphasize that we are well prepared and well equipped.
And
when we
this
say
had
that
been
they are
earlier delegated under the TT. So now if BDA has come, then that delegation should continue.
Yes, yes, sir.
That, I mean, so that I leave to you, Pratibha. You are all aware about these, and I'm sure Ashok Kumar would also take active role. Ashok, we didn't hear you. Maybe you agree to whatever we have discussed, or if you would like to add anything.
Sir, thank you, all of you. Thank you, Chairman, sir, for giving me opportunity to learn from all of you, because all of the senior persons from the ICR, NBPGR, other departments are also here, like Dr. Bara Prasad and others. So, sir, I am silently listening all the things from last, I think, 2 hours.
Yes.
So yesterday I could get a chance to attend this non-parliamentary committee under the chairman of Mr. Jairam Ramesh. So along with the Department of Agriculture Research and Department of Agriculture and Farmers Welfare, along with Dr. A.K. Singh and Dr. Dr.
Sir, you have taken oath before parliamentary committee not to say anything.
No.
Yes, so you cannot divulge. Otherwise, you could have all said that.
No, I will not saying that. I am saying that because I have to take our this recommendation in a very crisp manner, because we do not have time to discuss so many things. So definitions to be taken into care of, and that to be similarly the medicinal plant The crop plants may also be added. So 2, 3, 4 points can be added, and that will be taken care of for the betterment of this bill. But thank you. So thank for this. I am really grateful to all of you to giving me a chance. Thank you, sir.
Oh, well, we appreciate that. And really, you are the key persons yourself and Shobh, IRI, and BPGR. And of course, ICR will take at its own whatever is required based on our deliberations as well. And we are happy that DK had been involved right from beginning. And that's why we want him to be in this small group. There is no commitment of any kind, and there is no written statement anywhere. So whatever you come out with suggestion, it will be on behalf of the society or behalf of TAS or NAS. And it will strengthen your efforts which you are making. So nothing in that context. And I'm glad if Jairam Ramesh is there. Maybe I'll also try to speak to him separately. And but let our submissions go first. And I would urge you, since we are all, this is our bread and butter. I need not re-emphasize. And our activities, our work, all is going to be influenced if these required changes in the amendment are not brought in. So let's spend a little bit of our valuable time for another next 3-4 days, prepare this draft, then have it circulated among again all those who have participated. If last minute they have anything to add, and as Dr. Baldev said, he will be sending his write-up. Others will, Dr. Sharma said. So those can be taken note of. And we hopefully submit our submission before 31st. I don't know whether the date will be extended. Dr. Baldev, you want to again say something? Please go ahead. Most welcome. Unmute.
Yeah, sir. Thank you. Thank you very much. It's good idea to involve as many as possible in strategy genetics plant breeding or other societies if there. But to my mind came IAUA, if you feel appropriate, Heterogeneous Association. So if they can also send something.
Okay.
Yeah.
We can talk to them also. And I would urge to Professor R.B. Singh to see how it will be dealt with at NAS level. And maybe he is authorized by Mahapatra and take the lead role in it. This is my request, if that can be agreed to. And we would also like to see that the submission is in time, and as many as can do it. We have to take note of the submission from FSII, which Dr. Kondania is going to share. I will ask him, maybe he provides us by tomorrow or so. Then that will be available to this group to also look at. And I think many of the issues are already clear and shouldn't take long, and we don't have to make a big document. Just a few flag issues, and certainly why only Ayush practitioners? Well, because maybe COVID, maybe because of medicine, and maybe the concern by the government because a Ministry of Ayush has been established. Ministry of Agriculture is there already, taking care of food and security of all the Indians. So I think we have to flag it very clearly that not only Ayush practitioners, but also farmers and breeders in the public domain who had been serving the society as the national public good. So that has to be kept into consideration. So with this, colleagues, I need not take more of your time. And Anuradha, you have to.
Sir, I left in between. If you permit, I can say a few words.
Yeah, please.
सर एक्चुअली वो बीच में एक मीटिंग आ गया. I have
Where
to
were
join.
you? We asked you, but you are not there that time.
I messaged you, but your mobile is off.
Okay, okay.
Anyhow, sir. Sir, if you look at various act, चाहे PBRF है, Seed Act है, या Insecticide Act है, or then look at the this BDA. जो BDA का जो भी सेंटेंस शुरू होता है 9 से शुरू होता है, वो पहले से ही नेगेटिविटी ला देता है. आप बहुत सारे देखेंगे सारे क्लॉज नो. थोड़ा सा मेरे को भी जब मैं पढ़ता था, है तो छोटी सी बुक, पर सारे सेंटेंस नो से शुरू होते हैं. व्हाई इट कैन बी कन्वर्टेड इनटू ए लैंग्वेज जो है इसकी. सर दैट इज वन आई वुड लाइक टू से. एंड अदर थिंग सर, क्योंकि ये जो एक्ट है बीच में बहुत सारे IAS इसको इंटरप्रेट करते हैं. जैसे PBRFA में एक्सप्लेनेटरी नोट दिए हुए हैं, अगर बीच बीच में अगर हम एक्सप्लेन करते हैं इसका क्या मतलब है, तो आई थिंक वो असर फ्रेंडली हो जाएगा. मेरे को थोड़ा लगता है, क्योंकि जब भी मैं NBO बहुत सारी मीटिंग में जाता था, तो वो क्योंकि IAS तो लिखिर का फकीर होते हैं, वो उसके इधर टसमस नहीं होते, आपने जो में एक्सपेक्टेड कर लिया. तो थर्ड जो बात है, जो मेरे को आप लोगों ने भी उसको आज हाईलाइट किया, डेयर टुक बिगर रिस्पॉन्सिबिलिटी. डेयर ने कभी भी, चाहे ISPGR है वो भी DSC के पास में है, तो डेयर ने कभी भी इस तरह का रिस्पॉन्सिबिलिटी नहीं लिया. तो डेयर को वी हैव टू स्ट्रेंथन, उसको बड़ा करना चाहिए. ये भले ही DDG उसके पार्ट हो, तो इस तरह से अगर जब तक डेयर अपना एक बड़ा स्वरूप नहीं दिखाएगा, तो मुझे लगता है कि ICR तो एक सोसाइटी के रूप में अलग हो जाता है, तो उसका कोई रोल ICR में डेयर में ज्यादा रह नहीं जाता. तो जो मैं काउंसिल में फील करता रहा, तो ये 2-3 पॉइंट मैं ऐड करना चाहता. बाकी मैंने इसको देखकर आई कैन कुछ कर सकते हैं तो वो करेंगे. थैंक यू सर.
Thank you, Dr. Sandhu. We appreciate this again. And I would say that this group, when the draft is prepared and shared with maybe with me, also shared with RB Bhai, so that we can get any final input, and we'll try to provide some support, whatever needed. And we need to be very clear and not ambiguous in our suggestions, whatever, because parliamentarians are again very sharp people and would like to say why you are asking this, why it cannot be done by X or Y, why you want all those. So we understand that. And if there had been some discussions earlier by some of our colleagues, as was mentioned, then you know the background of what kind of deliberations and discussions have taken place. And maybe you can help us in articulating on those issues more clearly. So with this, Anuradha, you have the last word now. Thank you for organizing this.
Thank you, sir. Indeed, it is my great pleasure to extend a formal vote of thanks to all the participants who took time from their busy schedule and joined us for the meeting at an extremely short notice. To begin with, this meeting has been a very illuminative and learning experience, and I'm sure each one of us will agree that it has been a privilege to be amongst the iconic figures of Indian agricultural research and education, including 3 Padma awardees, namely Dr. Paroda, Dr. RB Singh, and Dr. B.S. Dhillon. It is indeed a big privilege to listen to you and learn from your vast experience. The meeting, of course, has been the brainchild of our president, ISPGR, Dr. R.S. Paroda. And it was at his motivation and guidance that we could arrange the meeting at a very, very short notice. Thank you, sir. And we will follow all the discussions, suggestions that have emanated from today's meeting and take it forward to a conclusive end of reaching our collected thoughts to the JPC. On behalf of the society, I thank Dr. Professor R.B. Singh for his tremendous, sharing his tremendous experience and also providing very useful suggestions, which we have duly noted and we will take them forward. I thank all my senior colleagues from ICR, Dr. T.R. Sharma, Dr. D.K. Yadav, and from IRI, Dr. A.K. Singh, for sparing the valuable time and providing us their perspectives. We have duly noted them and we will definitely be working upon them. Thanks to all the senior people who have shared the views today, including our directors from NBPGR, starting with Dr. Paroda, Dr. S.K. Sharma, Dr. B.S. Dhillon, Dr. Gautam. Dr. Gautam is to be thanked because he has seen both the sides from ICR as well as from NBA, and his experience is invaluable. So we will be in fact.
I think when you prepare the draft,
Yes,
Dr.
we will
Gautam
be
should
first
also
contact.
be consulted.
Yes, yes, sir. We will be taking all his using all his experience to refine the draft. We are thankful to each one of you who have given suggestion, including Dr. J.S. Sandhu, Dr. Bhagmal, Dr. Varaprasad, Dr. Karihalu, Dr. K.R. Narayanan, Dr. R.C. Chaudhary, and all the others, Dr. Umesh Srivastava, for sharing the views, and Dr. J.C. Rana. Dr. J.C. Rana is also the Vice President of our society. And we thank Dr. K.V. Prabhu, Dr. Kuldeep Singh, and Dr. R.K. Tyagi, who have provided suggestions for today's deliberations and who could not attend the meeting due to other engagements. ISPGR, as already mentioned by Dr. Paroda, would appreciate receiving any written comments, especially from my colleagues who could not provide the inputs today due to paucity of time. And I thank all my colleagues from NBPGR, all heads of division, Dr. Gurinder Randhawa, Dr. Veena Gupta, Dr. Celia Chalam, Dr. Vandana Tyagi, Dr. Ehlawat for their presence. And I am especially thankful to people who are COVID infected, Dr. Ehlawat and Dr. Yadav, who in spite of their illness have made it a point to attend the meeting. Thank you very much. I thank my colleagues, Dr. Kavita and others who are attending the meeting today. Special thanks to the organizing committee for today's meeting, Dr. Pratibha Brahmi, Dr. Vandana Tyagi, Dr. Sunil Acha, for making this reality. I hope I have not missed out anybody. And of course, our special invitees, like Mr. George Thomas, who could attend the meeting at a very short notice. Thank you one and all. We will be getting in touch with all of you very shortly. Thank you very much.
Thank you, sir. Thank you. Thank you very much.
Thank you very much. Thank you.
Thank you, everybody.
Thank you, sir. Thank you very much.
Thank you all.
Thank you.
Thank you.